5 seconds to go. Start. Even assuming that the arbitration process involved highly technical and complex issues which was time consuming, even then it was open for the arbitrator or for the parties to approach the court for extension of time to conclude the arbitration proceeding, which was not done either by the arbitrator or by any of the parties, as correctly noted by High Court in its impugned judgment. There was no cogent reason for the delay in making and publishing the award by the arbitrator. He already had the relevant materials at his disposal and could base his findings on the observations made by the three arbitrators who were appointed prior to him. It has been correctly observed by the High Court that the arbitrator had become functus officio in the absence of extension of time beyond 30th of September 2005 to make and publish the award. After the said date, the arbitrator had no authority to continue with the arbitration proceedings. The learned counsel, appearing on behalf of the appellant, argued that in the absence of any statutory period prescribed under the Act for rendering an award, the direction of the court to conclude the arbitration proceedings within the time prescribed by it would not make an award passed beyond the time so prescribed null and void. He further argued that the High Court was wrong in not extending the time fixed by it in the order for early conclusion of the arbitration proceedings and terminating the mandate of the arbitrator when neither the Act nor the arbitration agreement prescribed any time for making and publishing the award. So far as this decision is concerned, we may keep it on record that this decision was rendered under the Arbitration Act of 1940 and not under the present Act with which we are only concerned. In view of our reasoning given hereinafter and in view of the facts involved in this case, we do not find any ground to rely on this decision of this court for the purpose of this case. We have carefully gone through para 8 of the decision relied on by the learned counsel for the appellants. We may not forget that we are concerned in this case with the Arbitration Act 1894. Without going into the details of this decision, we may simply say that this decision cannot have any direct application. In his statement before the police, he said that in the morning he, along with his two younger brothers, PW6 and the deceased, was sitting on the chabutra of their baithak in their village when deceased proceeded for his house to bring the clothes for getting ready to go to Faridpur, where he was due to appear in the BA examination. As he reached the chopal where the lane turned, he was waylaid by the accused and his friend armed with knives. As to the cause of the said incident, He further stated that shortly before the occurrence, his younger brother was elected as the village sarpanch. He did not pay any heed to the unreasonable demands of the accused, and this greatly annoyed them as they thought of themselves as the Chaudhry of the village. This had led to an altercation and an exchange of hot words between the two sides on the previous evening, but the matter was then patched up by discussion. He finally stated that the accused, in league with one another, had killed his brother by giving him knife and lathi blows. After the occurrence, he brought his friend to the civil hospital Kanpur, where he was declared brought dead. Dr. Kumar PW3, who was in the hospital on duty, sent information in that regard to the SHO PS, whereupon PW8 came to the hospital and took down the statement of the appellant. The FIR was delivered at the residence of the area magistrate on the same day. What is, however, of significance for our purpose is that the trial court disbelieved a substantial part of the prosecution story. The trial court did not accept the prosecution case that accused were present at the place of occurrence and accordingly protected their acquittal. As regards the trial court pointed out that the three incised wounds on the person of the deceased that were attributed to him were, according to the medical evidence, post mortem in nature, that is to say, those three injuries were inflicted after he was already dead. The medical evidence thus clearly eliminated the participation of his friend in the case. He too was therefore acquitted. The acquittal of the three accused brought down the number of the remaining accused for the shared common intention with the appellant. Apparently, that was one of the reasons for their conviction simply under section 323 of the Code of Criminal Procedure. Stop.